And you picked up yet another possession or use of an abusable volatile. I don't even know what happened because today is the day set for arraignment on this case. What happened on the new case, if you don't mind?
Do you want me to repeat the judge?
Yeah, please, because I've not even heard it to know what happened.
Yeah. I also spoke to the witness yesterday, so I think 20 minutes from
Great.
now. But on October 17th of 2024, officers responded to a welfare check at the Dollar Tree located at 14324 FM 2920. A witness stated she observed the defendant inhaling from a can of multi-purpose cleaning duster and later observed the defendant slumped over on the steering wheel of her motor vehicle in the parking lot. Upon officer's arrival, officer observed the defendant sitting in the front driver's seat of her motor vehicle with the motor vehicle running in the on position. Officer also observed several cans of multi-purpose cleaning duster beside her. Officer observed the defendant to be confused and disoriented. She admitted that she had entered the office depot to purchase several cans of duster with the intent to inhale chemicals in a manner contrary to the directions, cautions, or warnings appearing on the label. And the defendant stated she did so to create or induce a condition of intoxication, hallucination, or elation. And she was found in possession of 3 10-ounce cans and 1 3.5-ounce can.
Is there anything else that you wanted to add to this?
Me, Judge? So the witness who spotted her, she had pulled into the Dollar Tree, parked there, and the defendant's motor vehicle was right next to hers, and she had noticed that it was on. So the witness, she went into the Dollar Tree, then went down to Target, did some shopping, came back an hour later and noticed that the truck was still there and still running. So she got worried, looked through the window, and she found the defendant slumped over. She stayed watching her for a while to make sure she was okay. She didn't feel comfortable driving off. That's when the witness saw her lift her head up slowly and inhale from the can. Again in front of the witness, and my witness, she told me, and then she slumped back down, and that's when the witness called 911 because she was worried about the defendant driving off in that condition.
I've spoken extensively with Ms. Stepanski about this, Your Honor.
You said the exact same thing to me when we came here the first time, and now she has a new case.
Yes. True statement, Your Honor.
How do we get her to stop?
Well, in talking to the state, so the plea agreement that we have agreed to with the state is the maximum length of probation to 2 years of probation. So that she'll be closely monitored during that time period.
I can't monitor her 24 hours a day, though.
Yeah, but she knows that she's, subject to, random testing or urinalysis and different things.
Still not going to show. I'm forbidding you from going to any store that sells this kind of stuff. You're not to go to any Walmart. You're not going to any Home Depot.
So she's also going to sign a no driving affidavit, Your Honor, and so only her husband would be driving her anywhere. And so I think that her husband threatened her to divorce. This is me being frank, over this. If this ever happens again, her husband's divorcing her, is what he's told her, and is going to be closely monitoring her. And she's not driving by herself.
You realize that what you're doing is you deprive your brain of oxygen when you do this, and at some point perhaps you'll hemorrhage yourself, perhaps you'll end up brain dead, you'll incapacitate yourself, that you're going to be unable to without the ability to speak. But you do this, and then you get out there and it happens again.
It scared me so much this time, and
I believe it. I believe it. I don't believe one iota. Nope. You sold me the same thing.
I'm currently attending NA meetings, which I will continue to attend.
I think that, like I said, the combination of her not being able to drive to be able to go get this stuff, and her husband helping to monitor that and enforcement of the 2 years of probation and making sure that she knows that, she's under
I have a sponsor.
surveillance, that I don't think it will continue to be a problem. I think that when there's been monitoring, there hasn't been a problem. This is just me kind of pulling back the curtain here because we're entering a plea.
Sure, Haddad, how do we get it to stop?
This is, man, I'm sorry, Judge, if I could just finish that thought for a second.
Look, I'm all ears
Yes, sir.
with any recommendation as how to get it to stop, because I mean, it's not something that I can test that'll show whether someone's using or not.
Judge, at this point, I mean, I was hoping that the TRS would recommend something such as like HUA, that's like a intensive treatment made for women, that's,
Yes, I mean, yeah,
I'm thinking HUA might be a good place to put it.
Figure out what the TRS is kind of.
Right.
I think that that's the best thing that we need to do. Yeah, I think that,
But my opinion, Your Honor, is that the no driving affidavit will cover or will fix the problem. This was when as soon as she started to drive, basically it became the problem. When the husband said, okay, you can drive, then she went to the store and did that. But without her being able to drive, and like I said, the husband making sure that that's not happening, because again, he's not tolerating any of
is
this.
the husband here?
He is not here today, but I can get him here if you'd like, Judge.
I mean, I think, Michael, I think you hit the nail on the head. I think what we need to do now, and Craig, I think what we need to do now is have our TRAS to see where we go, because we have clinicians that will be able to tell us how to tackle this problem, because I'm truly at a loss of how to get it to stop, because theoretically this is something that you can get anywhere, right? You can have it delivered through Amazon, right? So
Sure, but that hasn't been her MO of doing any of this. I understand you. I hear your words.
she's been able to drive.
I understand.
Right.
Well, she wasn't able to drive for a while after this happened or whatnot, and then it wasn't a problem. And then when driving resumed, then that resumed being a problem. So that's why I
I
think
don't know that for
the no
sure.
driving affidavit would fix that.
Ms. Brown?
I mean, I've explained to her that, what she's signing up for, is a lengthy probation. It's a 2-year probation with potential constant monitoring that whole time, plus whatever TS conditions and other kind of help that they can, help her with. And then, that if she messes up in probation, that she signed up for, 180-day jail, that's what she's understanding. I know that when she was in jail, she spent 3 days in jail on this new offense or whatever, and I know that was a pretty devastating experience for her. She's 65 years old and takes a ton of medicines, which she didn't get and stuff when she was in jail, and I know that was a big deal. She's having panic attacks in jail and things, but I think the conditions that we've agreed to with the state are sufficient. I mean, I wouldn't have signed up for
I mean,
it.
I'd like to put on there no possession of any kind of volatile container that can be abused
That's
to get
fine.
high. I want, no going to Home or Office Depot, Walmart. Ma'am, I want you to understand that if I find you with another of these containers, and I don't care what you're doing, where you're going, who you're with, I'm going to put you in a rehab facility in the jail. And if that's what we need to do to get you to stop, I'm going to do it in a heartbeat. Do you understand? I mean, you're killing yourself slowly. That's all that's happening. And the problem is that everyone around you is suffering. What happens if you do this in the middle of the road while you're driving? I mean, God, if you kill someone, you get charged with murder. Is that the last thing we want you to do is to spend the next 30 years of your life in prison because of a drastic and catastrophic event where you kill someone. And in that kind of stupor state, if you're in a car, you're begging for it to happen. Okay, so I guess I'd like to do the TRAS to see where we go. So what we're going to do is I don't know. I don't know how to move forward with this, Ms. Stefanski. So what I'm going to do is I'm going to have you evaluated by our clinicians to see what they suggest is the best way to go forward. So I'm going to have you meet with them, and I want you to be honest because I want to move forward in the best way possible. If you're not honest with them, a motion to revoke can be filed. We'll put you in custody and we'll do it next time in custody. I don't want to have to do that. So be honest in the evaluation. Be honest with yourself. I'm now taking away your privilege to drive for a year. You're not allowed to drive. You're not allowed to use be in possession of any kind of container where you can get high from it. And I don't want you to go to any Office Depot. I don't want you to go Walmart or any of these places that you can also buy these from. You understand?
Sir.
It's 180 days in jail, probated for 2 years. You will do thinking for a change, a DWI education class, 2 victim impact panels, a TPAS, with the conditions you must fulfill: substance abuse treatment, no breath test refusal, no drugs, no alcohol, guardian interlock so that we know that you're also not consuming alcohol, and a one-time donation of $100 to Matt. Is this how you understand the agreement?
Yes, sir.
I think the max is a year, right? On the first, it's a year.
For probation.
Yeah. For license suspension, I think the max is a year. I mean, if it was 2 years, if I can do 2, I'd rather do 2 because I think that I just don't want you to go anywhere near a car until this problem has been tackled. Do you understand, ma'am? Do you have any questions?
Sir.
There are other things in life that give you that kind of rush instead of using a can. You need to find another outlet, but cans, that's not a good way to go because you're really going to sue some irreparable damage the last thing you need is to become a vegetable. And invariably it's going to happen at one point or the other. How do you plead to the offense, Mr. Stefanski? Guilty or not guilty?
Guilty.
I will find you guilty. I'll send you the agreement. Is there anything else that you wanted to add?
Nothing else, John.
Michael, anything else, guys?
No, just the other 2 cases.
Okay, so part of the agreement is this DWI, they're going to dismiss your other 2 inhalant paraphernalia cases as well, okay? All right, and wish you best of luck. We'll have you do the TRAS, and then I guess just give me a heads up when you do it, will you? And then, Craig, I'm going to reach out to you so you know. When we get it back, I'll let you know what it is. That way,
That's not.
that you know as well. They may say inpatient, I don't know.
Right, and you understand that. They could
Understand
give
that.
you inpatient treatment.
All right, ma'am.
We don't know.
Best of luck.
Depends on what they feel like is appropriate.
See you soon.
Thank you for the.
An arraignment, Barragan, B.A.
I'm ready when you are. You might bring them up.
Yes.
Good morning, Mr. Barragan. You were charged with racing on a highway. You were facing up to a year in jail. Up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 5th, 2025, the officer was part of a street racing and takeover task force and was advised of a group that met at a gas station parking lot in the city limits of Harris County, Texas. The officer was working in a plainclothes capacity and was following the group from one location to another and viewed 2 vehicles race side by side at Highway 290 and Kickapoo Road, traveling westbound. The officer observed the defendant's vehicle and another vehicle slow down to approximately 50 miles per hour before launching at the same time in a competitive manner, accelerating well over 100 miles per hour in an attempt to outpace one another. The officer maintained visual and was able to detain the defendant, the driver of the silver Nissan observed, but was unable to locate the other vehicle.
How fast are we talking over 100?
Let me see if he specified, if it was just that. The officer only said well over 100. He didn't specify.
Barragan, I'm ordering you as a condition of your bond not to participate in this kind of activity again. If I find that you're racing, if I find that you participate in any kind of street takeovers, anything of this nature, reckless driving, donuts, whatever, I will take your ability to drive away from you. Do you understand? Not only that, it is a condition of your bond, and if I find that you do, I can revoke your bond and put you in jail. Can you file those conditions, please?
Yes, Judge.
You're gonna reset your case to give you time to fight this thing. I'm gonna have you sign a reset victory. I'm gonna have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. You have a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're playing games, you pick up a new case, you've become a danger to my community, I will put you in jail. You understand? Okay, come on. Thank you.
Judge, I didn't hear, so PC was found, were there state's bond,
States conditions, yeah.
state's bond condition?
Yeah.
Okay, got it. Also, there was one more, sorry, off docket arraignment that was probation consent over here. So whenever you're ready, I'll know.
Okay, who is it?
It's a printout up there, last name Worthy.
Emmanuel Worthy, come up. Did you get the cause number for this?
Yes, Judge.
He's on probation. Has a motion been filed? I don't know, because the bond's still set at $100, so I don't know if a motion's been filed. Mr. Worthy, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 8th, 2025, the officer responded to a DPS agent who stated he was following the defendant's vehicle and needed assistance on the traffic stop, as the DPS agent was conducting surveillance on an unrelated case. The DPS agent provided a description of the defendant's vehicle, and the officer observed the defendant's vehicle failing to signal a lane change, along with the defendant's third brake light being out. The traffic stop was then conducted, and the officer made contact with the defendant. The officer observed a strong odor of marijuana, and the defendant was asked to step out of the vehicle, and the defendant stated there was nothing illegal inside. The officer located a cigar filled with a green leafy substance known to be marijuana based on training experience with a weight of 0.09 grams or 0.032 ounces. A PC search of the vehicle was conducted, and the officer located an unholstered black handgun inside a backpack in the back seat of the vehicle.
Mr. Worthy, I'm going to find that there's probable cause to go forward with the case. Take a seat for me in the jury box. Okay, come on.
Morning, Judge.
Hey.
Judge, I have a quick question. I have Jonathan Guidry Joyal popped up on my docket. The only issue, I would like to hear PC. The only issue is he's in processing. I don't know if you want to wait till he pops up, or can we hear PC?
No, we can hear PC, of course. Yeah.
Yes, Judge.
You don't think there's PC?
I think there's two main issues that I'd like for you to hear.
It's on the jail docket, unlawful camera. Okay, go ahead.
Yes, Judge. On January 8th, 2025, the officer observed the defendant's motor vehicle fail to signal for 100 feet prior to making a lane change twice from lane 3 to 2 and then from lane 2 to 1 on East Tex Freeway in Harris County, Texas. A traffic stop was initiated, and the officer observed further movements between the occupants of the vehicle before the driver, defendant Price, age 19, rolled down the windows of the motor vehicle. The officer approached the motor vehicle and observed a clear plastic bag with green liquid in plain view in the driver handle, believed to be promethazine based on training experience, and a bag with marijuana in the driver door pocket. The weight of the marijuana was 0.82 grams, and the promethazine was 101 grams. The officer observed an AR pistol in plain view on the rear left floorboard or left rear passenger seat, where the defendant, Guidry Royal, was seated. Guidry Royal, age 19, and a PC search on the motor vehicle was conducted, and the officer observed another AR pistol inside a black backpack in the right rear passenger seat where defendant Kinnan was seated, along with defendant Kinnan's cell phone. The officer observed an unholstered Glock in plain view adjacent to the first AR pistol on the floorboard behind the driver's seat. The defendant, Guidry Royale, stated the firearms were passed from the front to the rear of the motor vehicle, but would not state who handed him the firearms.
If I may, Judge, here are the issues. So some stuff that's not there is that they were looking at this vehicle beforehand. This is,
Remember, this is a probable cause hearing. I mean, I can't get into like,
correct.
you know.
It's a suppression team. They're looking, they're following. It's a contextual stop. They're following them, waiting for a reason to stop them. The reason that they give is didn't signal for 100 feet. Sounds like they're on the highway. Okay. It's a conclusory statement. They're not stating that anybody else was in danger. They make no mention of.
Well, failing to signal a lane change is a good, I mean, that's a traffic violation, is it not?
Well, 100 feet. They don't say at what point he failed to signal, whether or not he signaled at all, whether or not he signaled under 100 feet. They don't state at what foot or feet he did signal. It's conclusory. They don't give articulable facts regarding that. And so because it's conclusory and we don't.
I don't know. I think that there's enough probable cause to go.
Here's the second issue, Judge. The second issue is in the DIMS, this officer is stating that my client says they passed the gun to him and they handed the gun to him. That's what the DIMS says. But the OR says that my client says he doesn't know who tossed them from the front to the back. He doesn't say they handed it to him. He doesn't say they passed it to him.
But there was also an AR on the floorboard where he's sitting.
Right. He says that they're not his. There's 4 people in the car. There's 4 people in the car. And only 3 out of 4 get charged with an unlawful carry of a weapon. He doesn't say, hey, they handed it to me. Hey, they passed it to me. What he says specifically is doesn't know who tossed them from the front to the back. This correlates to the furtive movements that the officer is talking about. He never claims possession of these guns. The guns are all in the car. He says they're not his, says the guns are not his, but he gets charged for the UCW.
And we're supposed to just take it, then just believe his, right?
And Your Honor, if I may, and that's why, because they were found in the area where he was seated, the AR pistol, and he is underage at the time. That's the reason why he was charged, because he had them in his immediate proximity in the vehicle.
Yeah, I think that there's enough. Sorry?
It would be a question of fact, Judge.
Okay.
I think that there's enough, sorry.
Okay. Understood, Judge. Thank you, Judge.
Thank you, Ricardo. Mr. Doyle, you ready?
Sure.
Mr. Kim? Happy
Judge.
Friday.
Happy Friday.
Happy Friday.
I'm here on Mr. Reader.
Reader. Yep.
He's finally here today.
Do you mind bringing him out? What's new? Everything all good?
Just, getting kicking off the new year. Kid stuff. How about you?
Same thing. My life revolves around kids, you know?
My son still won't wear long pants, he'll still wear shorts.
In this weather?
It's,
Are you,
That's a thing.
my daughter wears them fine, but yeah, my son just
How old
refuses
is
to. He's 8, so
it's 8.
just doesn't care. Just he'll freeze to death before he
Well,
admits.
hopefully he's wearing a jacket and a sweater. I mean,
So it just
I
looks
you know,
comical, yeah.
I love shorts as well. And I hate wearing pants too, you know? So.
That was after.
Are you opposed?
So I'm not opposed to a bond, I'm just opposed to a low bond. And so council has shared some more information regarding, because we haven't been getting, it's another one of those, we can't get a hold of the people from the demanding jurisdiction. It's one of those because it's a to be warrant, it hasn't been assigned to a prosecutor yet. And so we were trying to get a hold of the actual investigator for this charge. And Amy and I got shuffled around a little bit, so we could only speak with the extradition investigator, but we couldn't speak with the original investigator. So my facts are very, very limited. We don't.
I'm happy to give you some background, Judge. Mr. Reader, military veteran, was a medic in the Pacific, in Korea, meritorious awards, done well. When he finished with the military, the Army, lived in Georgia, then was hired over here by a very reputable hospital and medical center. He's the lead administrator. He was referred to me by the chief neurologist of this hospital. What ends up happening, he is in a custody dispute, and I believe Judge Kirby's, is that the judge, over in family court?
Here or over there?
Here. As this custody dispute sort of soured for his future ex-wife, he shows up at his hospital to go to work and is sworn and arrested on a warrant that he had no idea about. Apparently, this is some allegation that occurred in Georgia in June of 23. No report was made at the time. I think the state will confirm that. It wasn't until the custody issue here started to go south for his future ex. She then makes an online report in DeKalb County, Georgia, who accept charges without ever even talking to him, getting his side of the story. There's actual video evidence, I'm told, of what happened that's been litigated in family court. They're not responding to the state. All we want is a low bond so he can go deal with this there. He's not a flight risk. He's not family here. He's obviously got a good job. His boss is the one who brought me in on this. And so, I don't want to ask for a dollar bond, but I ask as low as the court wants to go because it is a cash bond, and he's going to have to go hire a lawyer to deal with this.
So you're not going to go represent him over there?
I'm not. Well, I'm going to get it. I know. I stay in my lane.
Got it.
We're going to find somebody in DeKalb County that will make this go away.
So, Mr. Reeder, you are wanted out of the state of Georgia for aggravated assault and cruelty to a child. What we have here is, I don't know you. I've never met you before, but my main concern are two. Are you a danger to my community? And number two, most importantly, are you going to go back to Georgia? I have to make the bond sufficiently high if I give you a bond so that you're going to go back, because you are, as everyone, it's an inherent flight risk because you're a fugitive from another state.
Judge, if I could, one other thing. The aggravated assault, my understanding in Georgia, is the impeding breath statute here. And the child part of it is, the allegation is the 12-year-old child witnessed this. So it's not, there's no weapon involved or anything like that. It's a simple domestic violence situation.
Any prior criminal history?
No, he has no other history, Judge. And so I'm not able to confirm, but that seems logical in terms of when the warrant was dropped, but it is correct. The charges, the Texas equivalent would be impeding breath, and I guess, I don't even know if we have.
You don't know this with certainty that
No,
that's
for the charges it is, but for the date, I don't have any other information. Like I said,
I don't know the actual, what the facts,
yes, the strength,
impeding breath, or whether it's shooting a gun.
And then cruelty it's strangulation, and the cruelty to child is the fact that the 12-year-old witnessed him allegedly strangling his wife. So, but regarding that, because of the nature of the charge, it's that state requests a $10,000 bond. And so you're okay with a bond being set because he has no prior other criminal history. He hasn't exhibited any other information I could find that he's a flight risk. So,
okay. So state wants a $10,000 bond. What's your counter?
My counter would be 1,000, Judge. He's not going anywhere. He's got a good job here. He's got support here. I'm here. They're not bringing me here to run away from anything. We're going to go fight this case and clear his name. Everything is here.
You got to understand that, if I set you a bond, we expect you to follow through, and there are very serious consequences. You're old enough to know that actions have serious consequences. And if you fail to act, I'm going to set you a bond, and we give you 14 days from the date of your release to go turn yourself into Georgia. If you fail to do that, I'm telling you now, I'm not going to play. If you fail to go, I will issue a nationwide warrant for your arrest, and I'm going to set your bond at 0. You won't get another one. Do you understand?
Yes, Your Honor.
I don't know. So he wants 10, you want 1,000. I'll set it at 5,
Would you consider 2,500? Because my understanding, it's a cash bond. So we have to pay, we can't get a bondsman in here, pay the 10%. And he's going to need money.
I defer to the court. Sorry, I was working on the waiver withdrawal form because he waived in magistrate court. So I'm just working on the waiver withdrawal right now, but I defer to the court. I don't, because he doesn't have any other history and because I'm limited information, it's hard for me to make any further assertions because no
To the
one's getting back
state's
to me.
credit, they've gone out of their way to reach out to Georgia and they, and they're not responding. It's not.
He's great.
Lack of diligence on their part, but apparently DeKalb County doesn't find this as much of a priority to respond to them. And they've had 2 days while he's been sitting in jail.
Okay, I'll acquiesce to the 2,500.
Thank you, Your Honor.
Give me a moment. I have one form. Just sign them all. Give me like 5 minutes.
The only other thing that I'm going to counsel you is that you got to be careful, man. You know, what you do impacts everyone around you, you know, especially a child. You know, hell hath no fury like a woman scorned and a teenager out of control, because the teenager that's out of control can make your life a living hell. And when they see that kind of, it impacts everyone. And I'm telling you, it reverberates and it can just, like an infection, just grow out of control. 90% of the people in there now, no self-control. They get upset, they wig out, and they just go without thinking, hey, if I do this, what's gonna happen? If I say this, what's gonna happen? Just patience really goes a long way, you know? All right, I'll set the bond at 2,500. Just be careful, man. All right? Okay, Mr. Doyle.
Thank you, Your Honor. Now,
Thank you, Judge.
excuse.
Yes, sir. Just gonna have to, hold on a second. Hi.
Hi, good morning, Your Honor. I'm approaching on last name Moore, first name is Sheena.
Okay.
We have a bond violation.
Moore, come up. Please show up for the drug test. We're not asking for much. I'm gonna send you for a test now. If you fail it again, it's not gonna go well for you, okay? All right, we'll send her for a test now. Assuming everything's okay, we'll just give you normal reset, but please, no more, all right? Okay, good luck, man. Give me a second, guys. When you're cool, the sun shines on you indoors,
Well,
you know?
it's because brilliance from the bench is blinding me. So,
How are you?
it may be that coat.
That's what it is.
I'm good, Judge.
Mr. Coyne.
Angel Gutierrez, it's a DWI. I understand that you might want to talk about bond conditions.
Is this a new case?
Yes, it is.
Judge, it's set for arraignment, it was in felony court.
All right, Mr. Gutierrez, come up.
Page 5.
I take it you are also representing him upstairs.
I am, Your Honor.
Wonderful.
Oh, sure.
Mr. Gutierrez, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, at approximately 12:58 a.m., the officer observed the defendant's vehicle was in expired registration as of July 2024. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The window was not completely rolled down and the officer observed slurred speech and further discovered the defendant had an open warrant and asked the defendant to step out of the vehicle. The officer observed an odor of alcoholic beverage and bloodshot eyes, and the officer did search of the defendant and found a marijuana blunt in the defendant's front pocket. The defendant stated he was coming from a bar and was driving home, and the defendant stated he had 1 cocktail drink and 2 shots. The defendant admitted to smoking the marijuana before going to the bar in the car, and the defendant stated he was 3 out of 10 drunk when asked to rate his intoxication. The defendant refused to send a field sobriety test, and the DIC was read to the defendant, who refused to provide a breath sample. A blood search warrant was signed and executed.
Mr. Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. Do you understand?
Sir.
He has a prior FSRA and he's on bond for that case. Has anything happened to that because of the
I
DWI?
just signed on to that case. He was just recently arrested for it. We're in the beginning stages of
Is
this.
it a 2B?
It was. We're in the beginning stages of discovery, Judge. I know almost nothing about that case yet.
Is there a dead body?
No, Your Honor, it was a minor injury.
Great.
Yes, Your Honor, this is a leg injury.
On the FSRA?
On the FSRA, yes.
Okay, all right. Does he have a Texas driver license?
It's eligible, Your Honor.
All right, you are not allowed to drive unless you also have liability insurance. If you don't have liability insurance with your Texas driver license, you're not allowed to drive. If I find that you're driving also without insurance, I'm gonna revoke your bond. Do you understand? All right. Now, you got a great lawyer. It's your responsibility to listen to Mr. Coyne, and he'll tell you when you have to come back to court. If he tells me that you're playing games, you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Don't pick up a third case. 3 strikes, you know what happens, right? All right, come on. Thank you.
Judge.
He's gonna have to get with Fleischer for bond conditions. We'll have him sign a reset, and then you're good to go.
Thank you, Judge.
This way.
Yes, sir.
Cataract, Judge, I had surgery, so
Always a pleasure.
I wouldn't be disrespectful to the.
I trust you. It doesn't matter. Mr. McAllister, I heard the wonderful news.
Yes, Judge, and I actually hear about that, just in administrative stuff. I was hoping you'd sign the motion to substitute to free up Peyton. Did you, on a certain cause number?
Are you now inheriting hundreds of cases or what?
This one, yes. And this one in particular is just one of those, that they're on PTI and they have a setting next year, but we got to free him up because he's getting sworn in on Monday, so.
Tell him congratulations from me, will you? You know, that's great.
Yeah, but we're all scrambling just to
I can't even imagine, you know.
change the name of the website. There's some administrative stuff going on, but,
I got it. I'll sign it for you.
you signed it for?
Yeah, of course.
Yeah, okay.
Just let them know.
I'll let them know the
I
cost.
think I may have already signed it, actually. It's a motion to sub.
Yes. You signed it? You already did it, Judge. Sorry, before I left the courthouse, I told him.
You're okay?
Thank you, Judge.
Take care. John D.
Judge, this is Ms. Prince.
All right. Good morning, Ms. Prince.
Morning.
Ms. Prince, you were charged with false report to a police officer. You were facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 5 days in jail with credit for the 5 days that you've done. You need to understand that by pleading guilty, this charge is going to go on your record. It's going to be there for the rest of your life. From now on, you'll be facing a minimum of 90 days in jail. Do you understand?
Yes, sir.
You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you can never change this or undo this.
Yes, sir.
How do you plead to the offense, ma'am?
Guilty.
I will find you guilty, sentence you to 5 days in jail, give you credit for the 5 days. The enhancement will be abandoned, and good luck to you.
Earl Nabiyama, he's in custody. He was put out on bond for a felony and he picked up his DWI. So he's set for bond. Has the bond already been set for this one?
Let me see. Oh my goodness, 100,000 on that agra, or on the ag assault, huh?
Yeah, he doesn't think he can make it, so.
So what happened? He was out on bond for this?
Yes, well, I'm not over the felony, another attorney at the firm is, but yes, from my understanding, he was out on bond for the felony and then he picked up this DWI.
So they revoked it and raised it
Yeah,
to-
they revoked it and raised it, yeah.
Okay, whatever you want, you know.
Set it at 1,000.
Well, the bond is set at 5,000.
Oh, it's already set?
Already made bond.
Okay.
So there's nothing really for us to do. Felony court is 116. You want to set it for the day after? Or do you want a longer reset?
A long reset, because I don't think it's gonna get some.
Okay, whatever you need.
Thank you, Judge.
Yes, ma'am. Thank you.